down thy heavenly wisdom from above, to direct and guide us in all our consultations. And grant that we, having thy fear always before our eyes, and laying aside all private interests, prejudices, and partial affections, the result of all our counsels may be to the glory of thy blessed name, the maintenance of true religion and justice, the safety, honor, and happiness of the Queen, the public weal, peace, and tranquility of the island, and the uniting and knitting together of the hearts of all persons and estates within the same, in true Christian love and charity, one towards another, through Jesus Christ our Lord. Amen.
Be seated, please. Good morning, everyone, members of the House, and members of staff. I'm just extending a warm welcome to each and every one. We are back here to continue the work of the people and to ensure that the legislative work is completed. I'm certain that everyone is here bubbling and ready to go, refreshed after the break. I also want to extend a welcome to the members of staff under direction of the Clerk of the House of Parliament, Ms. Curtis, to you and all your members of staff. We welcome you back. I encourage all to strive for good order, efficiency, and effectiveness, especially in these challenging times that the world, including Jamaica, is going through with the COVID pandemic. And as you have heard some comments from other nations, that they describe it as being endemic, something that we may have to live with going into the future. I want to extend my congratulations to Ms. Curtis, who has served the Parliament since 1995, a long time. She has served as acting clerk since October of 2020, when Mrs. Cook took leave of absence, and she's now enjoying her retirement. Mrs. Curtis was appointed clerk in her own right on July 23, 2020, by His Excellency Sir Patrick Alley. Whilst congratulating Ms. Curtis on her elevation, we must thank Mrs. Cook, for her years of service. And in discussion with the President, our appreciation as a Senate will be shown to Mrs. Cook at another time in a more substantive way. And that will be in the very near future. I call to order the Senate in its meeting of September 17, 2021. I just ask from Leader and Senator Bunting, in respect to commendations to Mrs. Curtis, I open the floor to you for making your comments. Thank you.
Thank you, Mr. President, and I thank you for your warm welcome to members of this honorable Senate and to the members of staff. I join you in this welcome and express my shared hopes that this will be a productive and energetic session of the Senate, where the people's work is always at the forefront of our minds and filling our hearts as we serve. And I wish to also, of course, extend on this, on behalf of this side, our heartiest congratulations to Mrs. Curtis on her appointment as clerk to this honorable Parliament. As you have noted, she has given service to this chamber, in fact, to both houses, for 26 years, serving as both assistant and deputy, and of course as acting clerk since October 2020. I have written to Ms. Curtis to extend my personal sentiments and congratulations, but today it is my pleasure to be here at our very first sitting, guided by her in this capacity. And I think that it's a wonderful occasion for us to mark positively this morning. I know we have all benefited from her wealth of knowledge, her ease of manner, and her commitment to always finding a solution and delivering on results and advice when requested. So I know we will have many more productive sessions of this Senate, sittings of this Senate, where we will be guided with the benefit of her wise counsel. We know that your exemplary service to the Parliament has already been recognized by the government of Jamaica through the conferral of the Order of Distinction Commander Class, for which we congratulate you as well. But we recognize, therefore, that it is not us who recognize your worth, but indeed the entire Jamaica. So we thank you again for your years of exemplary service, and we look forward to your continued undertaking of same. Thank you, Mr.
Senator Bunting.
Thank you, Mr. President. On behalf of the opposition, I too would like to associate us with the sentiments you expressed in your welcome back, and specifically to join in welcoming Ms. Curtis in her new capacity at our first sitting since she has been elevated. My association with Ms. Curtis goes back to my first term in Parliament in the 90s. So after, that was when she first joined us in 95. I joined a couple years ahead of you in 93. But since then, for the 5 terms that I've been here, Ms. Curtis has been synonymous with a professional and a supportive parliamentary staff. Her approach to her work has been exemplary, and her quiet counsel, oftentimes given outside of the chambers of Parliament, but just a word of advice here, guidance there, has been invaluable, not just to me, but I'm sure to many, many of us who have served over the last quarter century. So we too are very happy for Ms. Curtis, who is like family to parliamentarians, and I look forward to her continued service, really as a model of the best traditions of our public service. Thank you.
And whilst we are on the comments, I will just make note of the fact that Senator Mayor Delroy Williams, who is not present in the chamber, is joining us virtually today, that he also is a recipient of a national award and we just want to extend our commendations to him. And whilst we were on our break during the month of August, former Senator K.D. Knight, who sat with us, sat with many of you, persons who have been here for much longer than I have been here. But I shared this chamber with him 2016 up until the time that he decided to take his leave. His wife, Dr. Pauline Knight, passed, and I wish to express on behalf of the Senate condolences to Senator Knight and his family on that loss. And also Member of Parliament, former Member of Parliament, and Senator too, Dr. Omar Davis. He also lost his wife. And we wish to express, as a Senate, our condolences to him and his family. And Howard Hamilton, us in the legal profession, Senator Scott Motley, Senator Minister Leslie Campbell, also leader. Sometimes we because you have been here and elsewhere, you don't practice in certain places, so sometimes we don't see in that light, but you are one of us in the profession. Howard Hamilton, who was a public defender also, he passed, and we just wish to, as a Senate, express our deepest condolences. Thank you.
Thank you, Mr. President. If I might just expressly associate ourselves with your words of condolences, which we, of course, wish to extend to our colleague, former colleague, Senator K.D. Knight, on the passing of his lovely wife, Dr. Pauline Knight, and, of course, to Stacy and the rest of the family on her passing as well. We also just express our understanding and deep sympathy, as this is a difficult time for families. I know it's particularly difficult for him and for them this week, and in fact today. And our prayers are therefore with them for strength, for consolation, for deeper understanding on which we need to draw at these difficult times. And of course, we pray for their peace during this very difficult time. And we also, of course, wish to add our sympathies to Dr. Davies on the passing of his lovely wife, Rose, who was clearly a trailblazer in the world of early child education. And in fact, I met her first when I was an opposition appointee on the ECC, and work was still being done on the new national curriculum for 0 to 4, which she was one of the critical leaders of that project. And she was, in fact, also a broad thinker. So my sister, who is an early childhood educator, had gotten a great deal of support for her when she was trying to do different types of studies of how to bring early childhood education and the importance of it to grassroots education programs. And Dr. Davies, that's Rose, and Professor Sams Vaughan were key cheerleaders and supporters in that regard. She was a special woman who also went to the same church that we went to, and will be missed by many. God grant her peace and her family peace, as her struggle with illness has been a difficult one for the family to manage. We also add our sympathies to the family of the first public defender, Howard Hamilton QC, whose eminence in the legal fraternity goes without saying very much more. He was one of Jamaica's in fact, the Caribbean's most distinguished attorneys. And we therefore send again our sympathies and prayers for consolation to his family. Mr. President, I would just note as well the passing of former President of the Nurses Association, Edith Allwood Anderson, a firebrand and advocate, fierce advocate for the rights of nurses, who we salute and thank every day for their work on the front line of this COVID pandemic. Her passing at this time brings to mind the importance of the nursing fraternity and the importance of protecting their rights. So we recognize her service to Jamaica and to the nursing fraternity, and we express sympathies to her family and friends as well. And we also, in closing, and it is a sign of the times, Mr. President, that indeed there are so many who are suffering loss at this time. And it really is an important part of managing the pandemic to recognize the emotional and mental part of what we are all going through as a society. But I add again, Mr. President, our sympathies to the family and loved ones of Ernest Smith, who also has just passed. He has brought so much joy to so many people with his broad personality. And Mr. President, also the passing, I'm just duly reminded by Minister Campbell just yesterday of Justice Stanley Clark and Horace Mitchell, Justices Stanley Clark and Horace Mitchell, who have been lost to the legal and indeed judicial fraternity. Jamaica supports and mourns with your families at this time, and indeed with all families that are suffering loss during this particularly difficult time. Mr. President, I thank you for your indulgence.
Thank you, Mr. President. On behalf of the opposition, I too would like to add some remarks and extend sympathies and condolences to all the persons mentioned. In fact, I feel it is a measure of my age that I served and know almost all these persons, in fact. And I perhaps start with my former colleague in the lower house, Ernest Smith, who I had a great fondness for, notwithstanding that he was on the other side. He was somebody who always had you in peals of laughter and who had a certain mischievous streak in him that you couldn't help but find appealing. I know many of his family, and we extend our condolences. And even while we speak to extend sympathies to our former colleagues, K.D. Knight and Omar Davis, I think it is important to recognize that their wives were public servants, outstanding public servants and Jamaicans in their own right. These were indeed superwomen, outstanding professionals, served in public service and academia, outstanding family persons, raised their, not just raised, but were dedicated to their families, their immediate families and their extended families. And I think it is worthy noting that they deserve acknowledgement in their own right. Howard Hamilton was the very definition of legal luminary and a great Jamaican that we can all look upon, and the first to hold that commission of Parliament as public defender, and therefore he will go down in the record books. And finally, I must also join, and since my colleague from this side, who is a trade unionist, is not here, but to give special acknowledgement to, as the leader of government business said, the firebrand, Edith Allwood Anderson. Her representation on behalf of the nurses was unique, was exceptional and was exciting. I still remember her quoting, "I have the tape. I have the tape," to warn then Minister of Finance and Public Service, Audley Shaw, to be careful in not living up to his commitments to her. Mr. President, the opposition joins in extending our deep sympathies and condolences to the families and to the wider communities for the loss of these great Jamaicans. I thank you.
All right, thank you, members. And at this time, I will be asking the permission of the Senate to allow Senator Williams to join us virtually. All in favor? Aye. Any against? The ayes have it. Statements by ministers. Announcements.
Laid on the table of the Senate today are the following. Ministry Paper number 56 of 2021 entitled The Department of Correctional Services Annual Report for the period January 1 to December 31st, 2015. Ministry Paper number 57 of 2021 entitled Annual Report of the Parole Board for the period April 1, 2018 to March 31, 2019. Ministry Paper number 58 of 2021 entitled Annual Report on Audited Financial Statements of the Coconut Industry Board for the year ended December 31, 2019. Ministry Paper number 59 of 2021 entitled The Biosafety Policy of Jamaica. Ministry Paper number 60 of 2021 entitled Update to the 2015 Climate Change Framework. Ministry Paper number 61 of 2021 entitled The Emissions Policy Framework for Jamaica. Ministry Paper number 62 of 2021 entitled Jamaica Deposit Insurance Annual Report for the year ended March 31, 2020. Ministry Paper number 63 of 2021 entitled The Annual Report on Audited Financial Statements of the General Legal Counsel for the 2020-2021 financial year. Annual Report of the Jamaica Promotion Corporation for the financial year ended March 31, 2021. Annual Report of the Jamaica Intellectual Property Office for the years 2009 to 2010 and 2010 to 2011. Annual Report on Audited Financial Statements of the Kingston Free Zone Company Limited for the financial year 2018-2019. Annual Report of the National Water Commission for the financial years 2016-2017 and 2017-2018. Annual Report of the National Water Commission for the financial year 2018-2019. Annual Report of the Early Childhood Commission for the financial year 2019-2020. Annual Report of the Office of the Political Ombudsman for the financial year ended 2019. Annual Report of the Jamaica Fire Brigade for the year ended 2016-2017. Annual Report of the Milk River Bat for the year 2019-2020. And the Constabulary Force Act, amendment of Second Schedule Order 2021 under the Constabulary Force Act.
Bills brought from the Honorable House of Representatives. Petitions. Papers. Reports from committees. Notices of motion given orally.
Mr. President, I beg to give notice that at the next meeting of the Senate I will move the following motion. Be it resolved that the Constabulary Force Amendment of Second Schedule Order 2021 under the Constabulary Force Act, which was laid on the table of the Senate on the 17th day of September 2021, be referred to the Regulations Committee of the Senate for consideration and report. Mr. President, I further beg to give notice that at a later stage today, I will move for the suspension of the standing orders to enable me to take this motion.
Motions that may be made at the commencement of public business requiring notice. Motions relating to the sittings of the Senate. Motions for leave to introduce bills. Presentation of bills without leave of the Senate first obtained. Public business.
Mr. President, I now move for the suspension of the standing orders to enable me to take the motion, notice of which I gave earlier.
You have heard the motion for the matter, the order to be referred to Regulations Committee. All in favor? Aye. Those against? The ayes have it.
Mr. President, I now ask that the motion be approved.
Those in favor? Aye. Those against? The ayes have it.
Mr. President, today it is intended to start the debate on the Sexual Harassment Protection and Prevention Act 2021. Just to open the debate, we are looking at just one or two amendments, some not very critical, clause reference here and there, but about two that require a little more thought. And in that context, we are intending to circulate a list of amendments next week so that both sides can review them in the context of this morning's opening presentation and, of course, allow us to take the bill through all its completing stages on the 1st of October. Mr. President, allow me to say that it is an honor for me to take this bill, to pilot this bill. It's an honor for me to pilot this bill, which represents a significant milestone in our very long journey of seeking to provide improved protection to Jamaican women and men from sexual harassment as we work towards a more balanced and equitable society. The international community recognizes sexual harassment as a type of gender-based violence. It's placed in the discourse among such other violations of human rights, including emotional, verbal, physical, and sexual abuse. And indeed, while we must always be socially aware of all vulnerable groups affected by gender-based violence, including being sensitive to the fact that it can and does happen to men, the data does show that women and girls are disproportionately affected. It's something which, outside of data, our lived experiences make quite clear. So the language of the bill is gender neutral. No two ways about it. It protects men and women. The language is neutral and does not distinguish between genders. But because of the incidence of harassment being predominantly against women and girls, really, both internationally and locally, I know you'll forgive me if I lapse into speaking of women more often than not. But sexual harassment undermines the victim's dignity and self-worth, and it reinforces false gender roles and expectations. It is one of the threats to achieving the Global 2030 Agenda, on which almost every country in the world has signed off, and in particular Goal 5 of the SDGs, which is to achieve gender equality and empower all women and girls. It's also seen as a threat to Goal 8, which is to promote sustained, inclusive, and sustainable economic growth, full and productive employment, and decent work for all. Now, these goals translate into our local national development plan, our Vision 2030. Indeed, in its most general space, the goal that all Jamaicans are empowered to achieve their fullest potential. Mr. President, Jamaica is party to core international human rights instruments, including the Convention on the Elimination of All Forms of Discrimination Against Women. We're also party to the Inter-American Convention on the Prevention, Punishment, and Eradication of Violence Against Women. And we indeed have implemented legislation, domestic legislation, which supports aspects of these conventions. Unfortunately, with these conventions, notwithstanding these conventions and local legislation, women and girls do continue to suffer high rates of sexual and other forms of victimization. And a part of addressing this must be recognizing, quite simply, a woman's right not to be harassed at the will of a man who feels it is somehow his right to say and do as he pleases to a woman, regardless of how she feels about it. That is, I suppose, as simply as it can be stated. And though we have achieved progress in our societies, there is more to do. The passage of this groundbreaking legislation in both our houses of Parliament signals a new stage of Jamaica's commitment to these global goals and international conventions in solidarity with vulnerable populations across the world and indeed in the very local interest of our citizens. The law will not immediately fix what is such a wide practice, so normalized in our societies as to be viewed by many as something that's not actually a problem. It's viewed as not a problem. There are many people who don't fully understand sexual harassment and often still equate it in their discourse with flirtation. Some think that discussing sexual harassment is about emasculating men, and it is not. And this is why public education is so important, it's why the legislation is so important, and it's why public sensitization will be so important leading up to its implementation. Because at some point, if you want a more balanced and equitable society, then you have to change some of the building blocks that made it the way it is. For clarity, the bill is not about emasculation. It is not about removing the ability to flirt or start new relationships. It won't stop women who like to flirt from flirting, and it won't stop women who like you from giving you the signal so you know you can make a move. It is about the ones who don't want it. Quite simply do not. It is about knowing that if you are in a workplace or an institution for a purpose or seeking quiet accommodation, enjoyment of your accommodation, you will be protected against unwanted sexual advances. It is about explaining what those are, unwanted sexual advances. It is about protecting persons from making jobs and accommodation available subject to sexual favors and giving recourse to persons who often are not empowered to complain or in any event have never had a framework to prevent or protect them or give them any form of redress from experiences that depress them, disempower them, humiliate them, anger them, upset them, affect their productivity, make them leave otherwise good-paying jobs and fulfilling employment at one end of the socioeconomic demographic, or have them suffer through indignity at the lower end because there's no cushion or source while you look for another job and the children have to go to school. Mr. President, the results of the pilot Jamaica Women's Health Survey 2016 indicate that 24% of women reported being sexually harassed during their lifetime. That's 1 in 4 women, and that's reporting. So we know that it's likely higher. But it hasn't been studied scientifically here for very long. So there's not a lot of documented bodies of data about the impact of harassment on our people. Where the data exists, however, the evidence is clear that exposure to sexual harassment leads to physical, physiological, and professional consequences for individuals. Anger, stress, feelings of powerlessness, degradation, depression, anxiety, and increased alcohol use are all among the outcomes documented of sexual harassment. We also note that while this is groundbreaking in Jamaica, our Caribbean colleagues in the Bahamas, Barbados, Belize, Guyana, St. Lucia, and Trinidad and Tobago have already long passed anti-sexual harassment legislation. So the need to address this problem legislatively has been recognized across the region. Some are standalone, some are embodied in anti-discrimination legislation, and in 2, St. Lucia and Bahamas, their laws even make it a crime, make sexual harassment a crime. But recognizing the seminal change that this will be, we have not gone so far, not gone into the criminality. But the bill seeks to establish an appropriate and balanced approach for Jamaica. So, Mr. President, in so doing, members would be aware that this Honorable Senate appointed a special select committee comprising Senator Cavan Gale, Senator Dr. Sophia Longmore, Senator Campbell Rodriguez, Senator Scott Motley, Senator Fraser Binns, Senator Morris, and myself to sit jointly with a similar committee appointed by the House of Representatives to consider and report on the bill that is before us today. The committee convened a total of 24 meetings between November 2019 and May 28, 2021, spanning 2 parliamentary sessions. It is, as I said before, it's gender neutral, and it seeks to protect and prevent sexual harassment against both men and women, and this is important, in places of employment, in institutions, and in respect of accommodations, whether they be business or residential. The bill is arranged in 8 parts. Part 1 is a preliminary section, short title and interpretation clause, in which clause 2 sets out the definitions that should generally be considered in the context of the bill. And I'm just going to take us through some of them because they are the core of the whole framework. So institutions in which persons will be protected from sexual harassment include a school, college, university, and other place of learning or training, a correctional institution or lockup within the meaning of Section 2 of the Corrections Act, a place of safety within the meaning of Section 2 of the Child Care and Protection Act, or any other place for the custody of minors, a nursing home within the meaning of Section 2 of the Nursing Homes Registration Act, or any other place for the custody of the elderly, a medical facility and psychiatric facility, place for the use of any facility by members of any organization, and such other place or facility as the minister may, by order published in the Gazette, designate as an institution for the purposes of this Act. A sexual advance, Mr. President, includes any one or more of the following acts, forms of conduct or behavior. That is, it can be physical conduct of a sexual nature, a demand or a request for sex or favors of a sexual nature, the making of sexual suggestions, remarks, or innuendos, the showing of pornography or display of images or objects of a sexual nature, and any other physical, gesture, verbal, nonverbal, or visual conduct of a sexual nature. Now, sexual harassment is not just a sexual advance. Sexual harassment means the making of an unwelcome sexual advance towards a person by another person, which is A, regarded as offensive or humiliating by the person towards whom it is made, or B, has the effect of interfering with the work performance of the person to whom the advance is made, or creating an intimidating, offensive, or hostile work environment, and references to the term sexually harassed shall be construed accordingly. So it's in this context, Mr. President, why I emphasize the issue that I've heard a lot of people saying, and maybe I shouldn't say a lot, I've heard some people saying, but this means you can't even tell somebody you like them, how you going to start relationship. Unwelcome sexual advance. It just means being more thoughtful about how you engage and when you engage and where you engage. And it means that you consider the other party's interest. This is about unwelcome advances. And they are regarded, it's not just unwelcome, but regarded as offensive or humiliating by the person, or so affects their work or work environment in terms that are set out in this bill. So, Mr. President, who is protected by this bill? Workers are protected by this bill, and there's a broad definition here. Remember, I was speaking about decent work for all and the global goals towards ensuring that we have a productive and inclusive society. Workers will include a person who carries out work in any capacity for an employer, including work as an employee, whether in the private or public sector, a domestic worker. That's where it happens quite a lot of sexual harassment in the domestic field. If you speak to the Domestic Workers Association, they will tell you. A person engaged under a contract for services or a subcontractor of that person, an employee of a person or subcontractor, a person whose service is procured or arranged by a company which is supplying, in the business of supplying workers for other businesses, so even where you outsource, trying to ensure that it's not the business relationship that defines whether you're protected or not. It is the work environment which will define it. So an apprentice, a trainee, or an intern, a student gaining work experience, a volunteer, or a person of a class designated by order by the minister. So, Mr. President, and this Act doesn't make a distinction between whether you're employed under a contract for service or a contract of services. Once you're engaged for work, whether it's formally or informally, and whether it is under contract or general employment terms, this Act is intended to provide you protection. Mr. President, there are additional considerations. I had mentioned before some considerations about what an unwelcome sexual advance, how it would be considered sexual harassment. The clause actually goes on to give a little more about how they should be considered. So in determining whether the act complained about is an act of sexual harassment, it must be considered, all of the circumstances must be considered. All the circumstances surrounding the act, conduct, or behavior should be taken into consideration. So it's nothing just that is prescribed that if somebody touches you, it is automatically sexual harassment. No. All the circumstances must be taken into consideration. There is no intention for this to be any sort of extreme, interpretation of what an unwelcome advance will be. All the circumstances must be considered. It must be considered whether the act, conduct, or behavior was a course of conduct. Is this something that's repeated all the time? Or is it a single instance? And if so, if it's a single instance, is it of such significance that it rises to the level of sexual harassment? These are the considerations that are put forward. And another important point, Mr. President, is to make clear that this act doesn't apply to persons below the age of 16. So certainly if you're in an educational institution at the age of 17, one would anticipate that the vulnerabilities there, as we have heard about in the public domain at institutions in the Jamaican context, this offers protection to you. Once you are under the age of 16, there it is that the criminal law takes effect in respect of protection of children and abuse under the Child Care and Protection Act. So there's a passing off of the liability and a scaling up of the liability once we are in the realm of children. So, Mr. President, Part 2 of the bill embodies the prevention aspect. And this part highlights the duties based on employers and persons in charge of institutions to prevent the occurrence of sexual harassment. So there are really two main duty bearers in this act. One is the employer, and again, as I said, that is anybody who engages work. And then there's a person in charge of the institution, and I read out the very long list of institutions that will be covered. Clause 3 imposes a duty on an employer and each person in charge of an institution to make every effort to ensure that their employees, students, residents, wards, inmates, patients, or members, as the case may be, are not sexually harassed. So that's about setting up a place of work or an institution which is not one where you are prone to be harassed. You're not vulnerable to it. That you have a duty to create that space. One of the tools that will aid in the prevention of sexual harassment is the policy statement, which is attached, a form of which is attached to the bill in the schedule. Clause 4 creates this duty to issue a written policy statement, and a policy statement is attached there. And it gives the elements so that certainly if you are a much smaller, less formal institution, what you would provide would not necessarily be the same as what is attached to this bill, which is quite intensive and I think perhaps at a level more easily absorbed by corporate. But certainly the ministry responsible for this act is already discussing through the Bureau of Gender Affairs how to provide simplified models for MSMEs and in particular M's and S's, micros and small businesses, who may need something far more simple to convey the intent, which is essentially the demonstration of respect to one another and freeness, and rather freedom and protection from harassment. Mr. President, 4.3, of course, sets out some of the details of the policy statement, and the bill mandates that the policy statement should be instituted in every entity across the island within 12 months from the commencement of the date. So there's a 1-year period from when the bill comes into effect that persons will have to understand the new paradigm, to seek assistance from the Bureau of Gender Affairs where necessary, to put arrangements in place where necessary. If you need to have sensitizations sessions with staff, those things can be done within the 1-year period. And the Bureau of Gender Affairs, I know, has already been going to different institutions, sharing information about the bill even before it passes, and that will be ramped up after its passage. Just going to note a very small amendment that will come in 4.3, and that's just in 4.3b, subparagraph Roman numeral 3. After the words members, the rest of that subparagraph will go back to the margin to qualify the whole of that section. So that's just to ensure that the statement that's being referred to in terms of the definition of sexual harassment, the framework for sexual harassment, is clear. Mr. President, clauses 5 and 6 are identical in terms of how the procedural steps that they set out for the lodging of a sexual harassment claim, either in a workplace or institution. And they both instruct complainants to lodge complaints in writing. And 5.2 provides that where it's lodged with the employer, that the worker must be notified, that is the person against whom the claim has been made. They must be notified in writing or electronically within 2 days so that there is no sitting on the matter. Things must be dealt with in a timely way. And in the case where the claim is made against a client, take such action as he or she considers appropriate in the circumstances. So I draw this to your attention that this act protects workers from harassment by clients. So if you work in a bank, the customer who comes in and tries to rub down or take a squeeze or to make inappropriate comments every time he comes to your cubicle or your what do you call it again? Workstation is fine. Thank you. But that you have a duty, you have a right to report it to your employer, and and they have a duty to take action. Because the fact that the person is there as a client does not give them a right that elevates them above your right to have a comfortable, safe, and productive place of work. Just a tiny amendment in that 5.2b2, you'll change the to a before the client, the article, so minor change there. And an investigation must be started, Mr. President, within 14 days of the claim being lodged, and the investigation must be completed without delay. So people mustn't have allegations made against them that are dragging and causing discomfort. Things must be dealt with in a timely way to ensure that matters are dealt with appropriately and solved in the interest of the person who has the harassment perpetrated against them or who is so alleged, as well as the person against whom the allegation has been made. And this is replicated under Clause 6 in respect of institutions. Mr. President, Clause 7 provides for the lodging of harassment claims against employers or persons in charge of institutions, and it encourages the exhausting of internal complaint mechanisms and procedures as outlined in the policy statement before a matter goes to tribunal stage. So remember earlier I spoke about employers having a duty to create a space which doesn't foment harassment. Part of that is, of course, having complaint mechanisms or procedures, no matter how simple or complex, depending on the size of your organization, but there should be a way in which an employee or a member of the institution can make a complaint. And this clause also provides that where the employer or person in charge is the alleged perpetrator, then a complaint can be made directly to the tribunal, because certainly it would be counterproductive to insist that a person make a complaint to the person who they are accusing of perpetrating the harm against them. Mr. President, Clause 8 requires the maintenance of a confidential register which will document information relating to complaints of sexual harassment for a period of 8 years. And this is just basic information about the particulars of the claim and when it was lodged, any action taken, and any other particulars as may be prescribed. And it imposes a strict regime of confidentiality and lawful disclosure on these matters. In fact, a person who knowingly or recklessly discloses information kept in a register commits an offense and shall be liable to a fine not exceeding $500,000, or in default of payment, of course, to imprisonment not exceeding 1 month, which is consistent with similar provisions in other bills. Mr. President, Part 3 addresses forms of sexual harassment and related prohibited conduct. And it just goes into more detail about how sexual harassment may take place in places of employment and institutions. It prohibits an employer or supervisor, for example, from making it appear to a worker that the prospects of work or working conditions are contingent on the worker's acceptance or tolerance of sexual advances from the employer or supervisor. And you read the words and you think that these are things that women live through every day now. You need the job, you're 19 years old, just out of school, can't quite afford to go to university, have 3 siblings that you have to help to send through primary and high, one about to take CXC. Money is short and you need the job. But the prospective employer feels that it is his right to make you know that he can have his way. He can not only be tempted to touch, he can touch when ready. Yes, I asked for your forgiveness earlier. Yes. People, victims, what I said earlier at my introduction was that, let me repeat it, thank you. The bill is gender neutral. The bill is gender neutral. It protects men and women, but we all recognize that it happens more to women than to men. And therefore, the examples that I most readily drawn, the ones that have been shared with me most often, are those of women. And that is the reality. So I apologized early on, but it is the information base that presents itself most often in this country, and that is the reality, and internationally as well. So it's not that it doesn't happen to both sexes, but it happens more to women and it happens more to girls. That is the reality. But I agree it's important to keep reiterating that the bill is gender neutral. It protects both men and women. So nobody can play in your locks if you don't want them to. Well, there you go. So it's not unwelcome. That is the point. That is the distinction. And it's perhaps conversations such as those that will help people to understand that it is about the unwelcome nature. It doesn't change relationships between men and women generally, except that there is an elevation of the level of respect that must be paid to understanding what the other person wants and welcomes. So thank you for helping me to share that point to the listening public. So, Mr. President, it's also, in respect of the workers, I know we will hear more in further presentations, it should not allow an employer to have a worker feel that they will suffer any form of disadvantage in connection with their work or employment unless they accept or are tolerant of sexual advances from the employer or supervisor. And here the language is all worker, employer, supervisor, not male or female. That's how it continues throughout the bill. So, and it outlines some of the very clear mandates or prohibitions. So a worker shall not sexually harass a co-worker as well. So it's not only about a power dynamic, it's about the work environment in which you are. Somebody who works with you shouldn't have a greater right to harass you just because they can't affect your employment terms, but they affect how you feel at work. That is, you can feel humiliated, distressed, violated by someone who has the same level of work as you in a work environment. They shouldn't have a better right to do it because they don't have power over you, so they are included. Can't harass a co-worker. A client also shouldn't harass a worker, as I explained earlier. A worker shouldn't harass a client. You shouldn't go into a bank or other place of custom, and every time you need this particular service, the person just cannot get to doing business, has to have some sort of inappropriate conversation with you for you to get the service that you need. It's not appropriate. So a worker shouldn't sexually harass a client. A worker shouldn't sexually harass a supervisor. A more interesting provision in here, and one that had quite a bit of debate. I'm sure we'll hear some more about that in the debate as well. And a worker shall not sexually harass an employer. Again, quite an interesting provision, but these things occur where the power dynamic is complicated. And a prospective employer shall not sexually harass a person who is seeking employment. A prospective employer shall not make it appear to a person seeking employment that the offer or the terms are contingent on the acceptance or submission to sexual advances from the prospective employer. Clause 10 addresses the same circumstances, but in respect of institutions. So it deals with members of staff, persons in position of authority, and students, residents, wards, inmates, patients, or members, as the case may be. Mr. President, Clause 11 deals with accommodation. So where someone is seeking to rent a place or to license a place to stay, and they are made to feel that getting such accommodation is contingent on their acceptance of sexual advances. And Mr. President, so that Clause 11 goes into a little more detail about that, and there may be persons who wish to share a little more about that. But it touches on eviction and pricing and benefits, essentially, that are tied to the acceptance or submission to sexual advances. And Mr. President, Part 4 deals with designation of authorized officers, and these are field officers of the Bureau of Gender Affairs who will be empowered to help empower employers and persons in charge of institutions to keep their environments free of sexual harassment and institute the required policy statement. So Clause 12 goes into that and speaks about persons who fail to comply with directions and they commit an offense and will be liable on summary conviction to fines not exceeding $1 million. Persons who assault or willfully obstruct or fail to comply with lawful requests of officers in the performance of their duties similarly commit offenses and are liable to fines as well. Mr. President, so this is about implementing the Act. Part 5 focuses on the tribunal, its creation, its functional requirements, methods of appointment, and other processes. And Clause 13 and 14 set out the membership of the tribunal and the appointment of the chairman and deputy chairs. Just want to say that in Clause 15, which speaks to jurisdiction, we'll be including clauses reference to Clause 5.3 and 6.3 for clarity. And Clause 16 speaks to hearing panels of the tribunal. So the tribunal will actually hear complaints in panels of 3, and there's a provision in Clause 16 that these panels be gender balanced. And this just really means that you shouldn't have a panel of all men or all women. But we're looking at some language to make that clear because it is a panel of 3, so using the term gender balance seems a little broad. The point is to just make it clear that a panel must have men and women on it, whether 2 and 1 of either. Right. Clause 17 seeks to compel a member of the tribunal who has an interest in any matter to declare interest and to not participate in deliberations or decisions of the tribunal on that matter. And there's, of course, a 3-year term limit for members, and the provision, the clauses provide for the eligibility, ineligibility, and revocation, disqualification and revocation of their membership to the tribunal. Mr. President, just to say that in Part 6 addresses the procedure for making complaints, time limits for making them as well, and just want to clarify, because the issue of the statute of limitations had been a major concern for members of the public who were following the bill, and the original of which had included a 12-month period of limitation within which a complaint could be made. And what has been changed is that a period of 6 years, that is the usual civil period under civil law, has been applied. But it's been applied to a series of offenses, and those are under clauses 5.2, 62, 7, 9, 10, or 11. So those clauses are the ones that deal with, those offenses rather, deal with the duty of the employers and the persons in charge of institutions to communicate within 6 years. That is that period. Just to clarify that there is still a 12-month period, limitation period, which doesn't deal with the more substantive allegations, the more substantive offenses, but ones where the impact of the complaint is more narrowly time-bound. So a complaint that the employer or person in charge of an institution failed to ensure that the environment is free of sexual harassment, that is something that you only have 12 months to bring, because one would presume that at a later stage, 6 years later, after the circumstances have changed, etc., that it may not serve the interests of justice to be bringing such a claim. And this is the same in respect of disclosing certain information in contravention of 4.5. You have to bring that within a year, because it's presumed that the impact would have been felt within that period of time. And similarly, if a complainant isn't satisfied with a ruling, that should be done within a year. You can't 6 years later say you're dissatisfied about a ruling. If you wish it to be revisited, you must bring that to the employer or to the tribunal within 12 months. So the substantive offenses carry a 6-month limitation, but these 3 specific offenses only carry the 12-month period. And of course, Mr. President, the tribunal, under its powers in 27.3, in circumstances that it considers exceptional, can grant leave to expand time. That is, if the time has expired, they can grant leave. But in circumstances it considers exceptional, we're looking here at whether this clause should include the more general phrase around the interest of justice being served. So closer to the language that's applied for any application for expansion of time before the Supreme Court. Clause 28B, which is one that deals with the disclosure of information, or on the other hand, confidentiality of information about a complaint. 28B actually speaks to this, this confidentiality obligation falling away if it is determined that the hearing should not take place. And there is some uncertainty as to how exactly that would unfold. What does that mean in terms of the scope of what someone can disclose and to whom, if it is that the matter is not going forward? And therefore, it's being revisited to see whether it should be revisited, should be amended, or indeed removed. So that's 28B. 28A, of course, will not will not be removed. That is about making it subject more clearly to 35, which speaks to the power of the tribunal to make a ruling about confidentiality, whether of the names of the parties, etc., in the interest of the administration of justice. So where the hearing is proceeding, then that confidentiality clause in 27A has to connect to it. So that's one of the things that should be circulated for our consideration. Mr. President, clause 29 speaks about investigations being undertaken. And again, this is one of the more thoughtful amendments that's being proposed. And I have to thank Senator Ransford Graham for his eagle eye, his legal eagle eye, in raising this issue, which despite our broadest efforts, still hadn't looked at ensuring that the separation of powers between the tribunal exercising its right to investigate and to adjudicate are clearly separated, so that the issue of who appoints the person who is investigating, making that more distinct from the tribunal, which will have to adjudicate. Again, we are all familiar with the Fair Trading Commission case and the body of law that has come out of that. So we just want to make sure we're getting this completely right, so there are no challenges on the basis of procedure in this regard. So that is to be another one of the matters that's to come before us before we next sit. Before I next sit. So on clause 30 highlights where the tribunal finds that there's no evidence of sexual harassment or the complaint is frivolous or vexatious, they'll provide the complainant with that finding in writing, and any person against whom the complaint was made of the facts and reasoning, and they'll take no further action in respect. So this will ensure that there's clarity around the reasons. They won't just give a ruling and not explain. There will be some findings provided. The procedures that apply in respect of the hearing are set out in 31. And here there is the right for the tribunal to not conduct a hearing or discontinue it if the tribunal receives notice that a complainant doesn't wish it to be held or continued. And they may adjourn at any stage to allow the parties to negotiate a settlement by amicable arrangement. So there is some flexibility in the system to allow parties to work out any difficulties that can be worked out between them. There are many circumstances where they can't, but where they are, the tribunal the law empowers the tribunal to act accordingly. And Mr. President, this section, this whole part deals with all of the powers of the tribunal to request the presence of witnesses and to give each party a hearing and a reasonable opportunity to call witnesses, give evidence, examine and cross-examine witnesses, etc. Mr. President, as I mentioned earlier, 35 deals with the ability to make rulings about how the tribunal will be conducted in the interests of public safety, order, morality, and administration of justice, of course. And that can include keeping confidential the parties to the matter and ensuring that they are not published. And it has also indicated that no particulars of a complaint shall be published without the prior written approval of the tribunal. And this is to, again, reduce focus on sensationalism of these issues, which are sensitive and emotional, and to allow the parties to, allow the tribunal to make their rulings in an appropriate setting. Mr. President, clause 36 looks at the awards, and this is an area being reviewed again just to make sure we're quite clear on their jurisdiction and the appropriateness of this law. And 38 and 39 speak to appeals. Mr. President, Part 7 speaks to offenses and corresponding penalties. in respect of the actual procedure. So failing to turn up at the hearing without reasonable cause, failing to furnish information or produce documents, refusing to be sworn or make affirmation, refusing to answer questions, things which we have all heard of being done before commissions that make it difficult for a matter to be properly administered or effectively administered. It makes these things offenses so that the administration of justice can be served. And the fines are set out there in Clause 40, creates the offense of subjecting any complainant or threatening any person who's a part of the tribunal's process on the grounds that they have made a complaint or that they have furnished or proposed to furnish any information or produce any documents or function or to appear as a witness. So essentially anybody who is critical to this process, you cannot threaten them or subject them to any threat or harm on the basis that they are involved in a hearing. And Clause 41 deals with the offense of a person knowingly making a false complaint to the tribunal. You always hear persons speaking about, well, what if people lie? It is an offense under this act. We note, however, that these things are generally quite difficult to bring forward, and this was found to be the right balance in allowing for, in disincentivizing false complaints, but ensuring that there is a strong process within which complaints can be brought. Part 8, miscellaneous clauses, the final clauses in the bill, Mr. President, they prescribe additional measures for the functioning of the legislation, empowering the minister to make regulations. They will be subject to affirmative resolution, granting power to the tribunal to create its own rules.
Speaker's time is up.
Mr. President, the leader's time, speaker's time having expired, I propose that her time be extended to complete, sufficient to complete her presentation.
The question is that the speaker's time be extended to allow her to complete the presentation. All in favor? Any against? The ayes have it.
Thank you, Senator Bunting. Thank you, colleagues. And I'm, of course, just wrapping up now to say, of course, this provides for the review of the Act from time to time by a committee of Parliament. And the time here is unusually short, but the committee had thought that given how much of a sea change this bill is, that an earlier review would be better than a later one. We will see how that goes. But, Mr. President, this landmark bill is truly an incredible move towards the elimination of sexual harassment in the workplace, in institutions and accommodations. I just want to reiterate our awareness of the fact that this effort will require wide public education in a multiple and diverse spaces using different approaches and languages. And the Sexual Harassment Workplace Policy Statement template, which is easily adapted, has been created, but the Bureau of Gender Affairs is specifically charged to allow persons, to assist persons in implementing, and this 12-month period will be available as well for adjustment. It is hoped that this will allow for empowerment of both men and women, healthier workers, healthier students, healthier members of institutions, more productive workplaces. And I truly look forward to the contributions of both sides on this matter on the 1st of October when we seek to take the bill through its concluding stages. Thank you very much, Mr. President.
Thank you very much, Minister. Anybody speaking? Okay. Okay. All right. I thought that there was going to be some contributions made today.
No,
so,
thank you, Mr. President.
Right.
In light of the fact there are a few amendments, and we want to circulate them, especially in the context of the opening. So, you know, everybody can refresh their minds about the contents of the bill, which is why I went into such details. So it actually is not intended to do any further business today, Mr. President, and I ask that the Senate be adjourned for a date to be fixed.
All right, you had not indicated that you were suspending the debate when you had concluded, and that is why I thought that there was going to be some contributions made today. And that's why you had also opened by saying that you were making comments on the amendments which will be coming, and you went into some detail. All right, so that is where the miscommunication went. All right, so the question is that the debate be suspended until October 1, 2021. All in favor? Aye. Any against? The ayes have it. Can I get a motion for adjournment, please?
I think I just gave you one, but prematurely, so let me give you another one. Mr. President, by the Senate be adjourned for a date to be fixed.
You see what happens when we have communication in between two.
Day
All
one
right?
back, Mr. President.
Thank you. So the question is that the Senate be adjourned for a date to be fixed. All in favor? Any against? The ayes have it. The Senate stands adjourned.